Chapter 1, An Introduction to the Fundamentals of Dynamic Business Law, Part 2, presented by Kelly Hersick. The next major source of business law is state constitutions. Every state has its own constitution. Some colonial constitutions from the original 13 colonies, which then became the original 13 states, are older than the U.S. Constitution. For example, the Massachusetts Constitution became effective on October 25, 1780, and remains the oldest functioning written constitution in continuous effect in the world. State constitutions are often longer and more detailed than the U.S. Constitution, as they include not only state government structure, but also include guidance on the day-to-day interactions between the state government and its people. Formats of state constitutions vary widely. Some are similar to the U.S. Constitution format, but others are much different, such as Alabama, which has the longest constitution currently by a mile. They can also guarantee civil rights that the U.S. Constitution does not. For example, California's Constitution details more rights, more individual rights, than the U.S. Constitution expressly states. State constitutions are the second highest law in any given state, directly behind the U.S. Constitution. Kansas's state constitution is much the same as the U.S. Constitution in terms of format and content. Even so, it has been amended 97 times. Then there are states like Alabama, Texas, and California. Alabama not only has the longest constitution at just about 345,000 words, versus the U.S. Constitution that only has 4,543 words. It has also been amended 909 times. The Texas Constitution is very different from the U.S. Constitution, and it has been amended 498 times. The California Constitution details more rights and is longer than the U.S. Constitution and has been amended 512 times. Another source of business law is statutes. Statutes are legislative actions passed by federal, state, and even local legislatures. These statutes, rules, and regulations issued by legislative bodies and their interpretation is generally known as statutory law. Federal statutes are published in the U.S. Code, which is a collection of all the federal laws in one location. Each state also publishes its laws. For example, Kansas publishes its laws in the Kansas Statute Annotated, often abbreviated KSA. Local laws are also usually published. In Wichita, for example, local laws are generally published and passed as ordinances. The next major source of business law is case law. The laws of any society must be interpreted, as the boundaries of most statutes and regulations are not self-explanatory. The United States is a nation of laws, and we're very proud of that fact. We as a society are bound by the rule of law, and the laws of any society, including ours, have to be interpreted. The legislature may create law, they may pass statutes, but those statutes have to be interpreted by the courts because the legislature is often not clear in what they mean and how the statute is meant to be applied. In fact, a new statute will often be passed and business people will review it, but be uncertain as to the new law's meaning or scope. They often ask, does this apply to my business? Am I bound by this? This is where lawyers come in and ultimately the courts. Courts interpret statutes, and they have to do it based on the plain meaning of the statute, what the words actually say. Though if it is ambiguous, they may resort to determining legislative intent, what the legislature meant when enacting the statute, which can be challenging for any court. In the U.S., case law is the collection of legal opinions interpreting the law. These legal opinions are issued by judges. This is also called the common law. The common law comes from our country's English ancestry, where judges would hear cases in court and would issue a written decision in the form of a legal opinion. Then another judge in another jurisdiction or court might hear a similar factual case and looked to see if any other judges before him had issued a legal opinion that he might use to build his opinion in the current case. In this way, the law would be built through a series of these written legal opinions by judges. These legal opinions are law unless later revoked by new statutes. Businesses have to pay attention to legal opinions, particularly those businesses that operate nationally or even internationally. Because the law is open to interpretation, courts in different jurisdictions may issue contrary opinions on the scope of the interpretation of a particular law. Businesses really have to pay attention to legal opinions because the law is constantly growing, changing, and developing. A law professor of mine referred to the development of law as the gray scale. At one end of the scale is the white scale, which is that teeny tiny sliver of the new frontier where the law is advancing so fast there's just not any law to interpret. For example, where technology is being created so fast the law just can't keep up. It's completely wide open. Then there's the other end that is black. This is known as black letter law. This is another teeny tiny sliver. Black letter law is a law that is so established that there's no reason or room to reinterpret it. Then there's the rest of it, the other 99.9% of the law, and it's gray and open to interpretation and argument. For a business person, that can be hugely frustrating because businesses want everything to be black letter law. They want rules. They want consistent rules that they can live by because most businesses are like cruise ships. They don't turn on a dime. Businesses want stability and predictability, but the law is constantly changing and developing. New statutes are being passed, statutes are being amended, statutes are being revoked, new cases are being decided, new opinions are being released that become law. This can become frustrating for business people, particularly if they do business in more than one jurisdiction. For example, courts in Kansas may interpret a law differently than courts in Missouri. If your business operates in both states, it needs to make sure it's in compliance with the laws as interpreted in both states. Let's look at a concrete example. Let's look at a wage and hour law. A wage and hour law in Kansas may have similar wording and provisions to a wage and hour law in Missouri. As a result, your business may treat Kansas and Missouri employees the same under these laws. However, the Kansas Supreme Court may interpret the Kansas state law differently than the Missouri court interprets basically what looks to be the same law. So all of a sudden a business will have to have two different separate wage and hour law practices for its Kansas employees and its Missouri employees. And this was what makes business people unhappy. Next, we will discuss the content of legal opinions in general and how they're used by other courts. Legal opinions usually contain the reasoning of the court and the scope of the decision's applicability. Sometimes a decision is very narrowly applied, meaning it's limited to its facts because they're so unique. In other instances, they may have a wide applicability and it may apply across the entire country. This is called precedent. If I was studying for the quiz this week, I would remember this word. Courts rely heavily on precedent, the use of past decisions, to guide future decisions. Remember on the last slide when we were discussing the common law and how I discussed how it was built from one judge issuing an opinion to another judge looking to see if there was a previous opinion that might support his current opinion, and so on, so that the common law is built on these legal opinions? That's what precedent is. Now, courts don't like to be overturned. In fact, judges hate it. And so they're going to look around and see if there's any other opinion that might give weight to their current opinion so that they're not making a decision in the vacuum. This gives the law some stability and predictability, even though it changes over time. However, older cases can be overturned even if they are considered precedent. Cases are not written in stone, and newer courts or different courts can overturn their previous decision. A lower court can't overturn generally the higher court. In other words, a district court case can't overturn a Supreme Court case. The Supreme Court can overturn their own cases and any court below them. It kind of rolls downhill. For example, let's talk about Plessy versus Ferguson. Plessy v. Ferguson was a decision of the U.S. Supreme Court issued in 1896. It upheld the constitutionality of racial segregation laws for public facilities like schools, as long as the segregated facilities were equal in quality, a doctrine that became known as separate but equal. That was the law in the U.S. until 1954, when Brown v. Board of Education of Topeka was decided. This is actually a case that came out of our own state. Brown was a landmark decision of the U.S. Supreme Court in which the court ruled that U.S. state laws establishing racial segregation in public schools are unconstitutional, even if the segregated schools are otherwise equal in quality. It overruled Plessy v. Ferguson, which was the legal precedent at issue. Remember that the framers of the Constitution wanted to create a living document that would grow and change as society grew and changed. And that's what happened with Brown. A more modern court at the time reinterpreted the constitutional requirements, and they interpreted them differently and thus overturned that old precedent, Plessy v. Ferguson. When courts use previous precedents to decide a case, they are using a doctrine called stare decisis. In Latin, that means standing by the decision. Lower courts are generally bound by the precedent from a higher court, such as the Supreme Court in the state or the U.S. Supreme Court. This is called binding precedent. Courts can also use non-binding opinions from other jurisdictions if there's no binding precedent in that state or court. This is called persuasive precedent. Courts in Sedgwick County, when they're issuing an opinion, will look to see if our state appellate court or our state Supreme Court have opined on the issue. If there's no case law, they sometimes will take a look at surrounding states like Oklahoma, Nebraska, Missouri to see if a similar statute or a similar issue has been handled by those courts to see what they say. And that's called using persuasive precedent. The next major source of business law is administrative or regulatory law. Federal, state, and local agencies are usually tasked with the day-to-day running of the government, and they have to produce rules for people and businesses to follow when operating within a given jurisdiction. Statutes do not usually lay out an entire regulatory and enforcement plan. That's left to the agencies tasked with that particular area of the law. You have to think of statutes and constitutions as the bullet points in an outline. They're the big narrative ideas, but then the agency has to come in and provide the written narrative under each of those points so that people and businesses can understand the law and comply with it. Administrative law is the collection of rules and decisions made by administrative agencies to fill in those particular gaps or details missing from statutes and constitutions. For example, the Environmental Protection Agency, the EPA, is a federal agency tasked with environmental compliance on a wide range of federal laws that affect businesses. The EPA issues detailed regulations that are meant to ensure businesses are in compliance with all types of federal environmental statutes, like the Clean Air Act. Proposed federal rules are published for public comment in the Federal Register, and final federal regulations are published in the Code of Federal Regulations. State and local governments have similar schemes and also publish their regulations. Businesses have to ensure compliance with all levels of regulations. In Kansas, we have the Kansas Administrative Regulations, known as the KARs. These are where regulations issued by a Kansas agencies to implement or interpret a statute are published. These regulations are subject to court review through the Administrative Procedures Act or its equivalent at the state level. Another source of business law is treaties. A treaty is a binding agreement between two states or international entities. It's basically just a contract, and state-to-state treaties are very rare. And as a business person, if you work in an international company, you're going to be interacting with treaties mostly on a basis of trade. Trade treaties are probably what's going to be important to your business. These are the types of treaties and types of agreements that treaties can come in. They can be international agreements, covenants, exchanges of letters, conventions, or protocols. In the U.S., treaties are negotiated by the executive branch of the federal government. To become binding, a treaty must be ratified by 2/3 of the Senate. The next source of business law is executive orders. Both the president at the federal level and state governors at the state level can issue executive orders. These orders are directives requiring officials in the executive branch to perform their duties in a certain way. The president can issue rules, regulations, and instructions which have the binding force of law upon federal agencies, but do not require approval of the United States Congress. For example, during his presidency, Bill Clinton signed 364 executive orders, George W. Bush signed 291, Barack Obama signed 276 executive orders, Donald Trump signed 220, and Joe Biden to date has signed 114. Now, if you look at these modern presidents and you contrast them with Franklin Delano Roosevelt, for example, FDR signed 3,721 executive orders. Now, remember that governors can also sign executive orders. For example, Kansas Governor Laura Kelly signed several executive orders during the COVID-19 pandemic, such as the stay-at-home order and the order requiring people to wear masks in public. Now, executive orders are subject to judicial review and interpretation. The Code of Federal Regulations, the CFR, publishes all the presidential executive orders issued. Now, presidents claim the power to issue executive orders based on their Article 2, Section 1 powers to take care that the laws are faithfully executed. There are criticisms of the use of executive orders. The major criticism is that executive orders impede or usurp Congress's ability to pass laws. The idea is that the executive is supposed to enforce the law, not make it. Those that support the use of executive orders are those that believe that Congress moves too slow or is in gridlock on many key issues or immediate problems. Now that we've talked about the sources of business law, let's change gears and talk about the schools of legal interpretation. Throughout our country's history, several schools of legal thought on the appropriate scope and method for legal interpretation have emerged. Understanding these alternative methods for interpreting the facts of a particular case and the law that governs it helps business managers see the law as a human creation shaped by many perspectives and approaches to what the law means. Now, justice is supposed to be blind and rendered equally. The goddess of justice is usually represented as a woman wearing a blindfold, holding a set of scales. Judges are supposed to be neutral arbiters of the law who render fair and just legal decisions without prejudice against either side in the dispute. But judges are human. They're influenced by a variety of human factors. Some factors that can affect a judge's views can be when and where they grew up, their family background or family dynamic, where they went to school, whether they're married or have children, and even if they practice a particular religion, can play a role in how they view judicial review and the scope of judicial review on jurisprudence. Now, some judges view judicial review narrowly, while others see it more expansively. There are several schools of legal interpretation discussed in your textbook. The first is identification with the vulnerable. It is protection of the weak, such as children, the elderly, the ill, the disabled, or minorities. This is the key priority in this school. Historical or traditional. Stare decisis and the following of precedent comes from this school of thought. Then there is legal realism. This school of jurisprudence is based on the idea that when ruling on a case, judges must consider more than just the law. They must also consider such things as social and economic conditions. This idea comes from the thought that the law and the Constitution are living documents meant to grow and change as society changes. Brown versus Board of Education might never have been decided as it was without legal realism principles. Legal realism is a theory that all law derives from prevailing social interests and public policy. According to this theory, judges consider not only abstract rules, but also social interests and public policy when deciding a case. In this respect, legal realism differs greatly from legal formalism. Legal formalism, also known as judicial restraint, is a school of thought that is rooted in the notion that judges should only interpret the laws as written and not look beyond to such things as social or economic factors. Legal formalism is a theory that legal rules stand separate from other social and political institutions. According to this theory, once lawmakers produce rules, judges apply them to the facts of a case without regard to social interests and public policy. In this respect, legal formalism is the flip side of legal realism. They are, in fact, a mirror image. There is a subset of legal formalism known as originalism. In this school, judges focus on the original meaning of a law. Originalism is a theory of constitutional interpretation that asserts that all statements in the law, particularly in the Constitution and its amendments, must be interpreted based on the original understanding at the time it was adopted. Judges who adhere to originalism generally look to what the authors of the law, such as the framers of the Constitution, intended when they wrote the Constitution. A judge using originalism will look to what the drafters of a law thought the law meant at the time. With regard to the interpretation of rights protected by the 14th Amendment, for example, an originalist will look to see what the drafters of the amendment thought it covered and perhaps what the ratifiers of the amendment in various states thought was protected. The goal of originalism is to interpret the law without imposing any modern interpretation on it. Originalists believe that this allows for an objective and fair reading of the law. Now, critics of originalism note that finding original meaning and the intent of long dead legislators can be fraught with problems. It requires judges to be historians, and that it is easy to pick writings that support a judge's theory while ignoring contrary writings. In addition, particularly with respect to fundamental rights in the Constitution, it has the negative effect of freezing fundamental rights for people in the 18th or 19th century. There is one other school of interpretation that is sometimes mentioned in this group. It's called cost-benefit analysis. And this approach to legal change is tied to efficiency. Who does it help the most? Who does it hurt the least? Judges don't usually admit that they're looking at the cost-benefit analysis when creating an opinion, but it often creeps into decisions. The last thing we're going to discuss in Chapter 1 is global and comparative law. Comparative and international global law is extremely important to businesses given the global nature of our economy in the 21st century. Comparative law is simply the study of differences and the similarities between the legal systems of different countries. Technological advances, and particularly the internet, have made trade with other countries easier than in the past. We've truly become a global marketplace. Even though we have a large national market, it is affected by events in the larger global economy. For example, if the Asian stock market crashes, that's going to affect the local stock market in New York. Now, as a result, in the ease of trade, businesses have to be familiar with global trade laws that regulate business practices among nations. It's become vital. I mean, even you and I as individuals deal with international law in some respect, because you can go on Amazon or eBay and you may actually be dealing with a seller who's, say, in Great Britain or in China. And that impacts import and export duties, what you have to pay to have it shipped, whether you have to pay duty on it if it comes into the country. It really does affect us in our everyday lives, and it will affect you as a business person trying to operate a business in the 21st century. Taxation and import and export duties on goods are of particular importance to everyone. Currently, the WTO, the World Trade Organization, is the body that primarily oversees international trade. There is a treaty that creates the WTO, and the United States is a signatory to that treaty, and we are a member nation of the WTO.
The mission of the WTO is to encourage reduction in the barriers to international trade, and it also attempts to enforce agreements among its 160 member nations. There are cases where you can go to the WTO World Court. The members can negotiate to do trade sanctions on its members. There are a wide variety of reasons and abilities within the WTO to regulate trade among the nations, but it's primarily based on the cooperations of the signatories and the nations themselves who are part of the treaty.
This is the end of Chapter 1, Part 2.